This is the Week in Sustainability from Workiva Carbon, formerly Sustain.Life. It's where our team of experts and practitioners share weekly insights and commentary to keep you up to date about all things sustainability.
Welcome back to the Week in Sustainability. I'm Hannah Sofsky. I am a sustainability data analyst on our sustainability team here at Workiva Carbon. Today, I'm joined by Hassan.
Hi, I'm Hassan. I'm a senior consultant here at Workiva Carbon.
So today we're going to be diving into really significant Supreme Court decision released last week. We can expect this to significantly reshape the federal regulatory landscape across the board, but we will specifically be talking about climate change. So the Supreme Court decision overturned Chevron Deference, which is a game changer. For background, the Chevron Deference is essentially a two-part question or two-step process that's been in place for nearly 40 years at this point. The two questions it sets forth towards a regulatory rule made by a federal agency is, was the language in the original congressionally passed law ambiguous? And if that language was ambiguous, is the agency's interpretation of that language or of that ambiguity reasonable? And if the answer to both of those questions is yes, then the court has decided that it will defer to the agency's expertise rather than its own legal interpretation. This makes perfect sense because the court is not where jurisdiction-specific subject matter experts work. They work in agencies. And reversing Chevron means that the courts are no longer compelled to defer to agency expertise. So we'll break down really exactly what this means and how we got here, mostly sticking to climate change and EPA.
Thank you for the great introduction, Hannah. So what does this all mean? Well, until last week, Chevron Deference has given agencies like the EPA the flexibility to interpret laws like the Clean Air Act. This allowed them to address new and evolving issues like greenhouse gas emissions. Without the Chevron deference, the agency has essentially lost its ability to provide clarity where there is still ambiguity.
Exactly. So instead of defaulting to those two questions on ambiguity and interpretation, we can expect to see courts rule against a lot of possibilities that aren't spelled directly out in the law. This will hamper the EPA from enforcing rules that fall under the umbrella of the Clean Air Act. But it's not just the EPA that can be affected, and it's definitely not just the EPA that can be affected in the scheme of emissions relevance and climate change. We're expecting the Federal Energy Regulatory Commission and its authority over cross-state transmission lines to be impacted, as well as Security and Exchange Commission's efforts to require companies to disclose climate risks. Any federal rulemaking that relies on an agency's interpretation of ambiguous laws will now be up to the courts. And there are implications far beyond environmental regulation, but the Chevron deference got its start in the Clean Air Act and its interpretation, so we'll stay in that lane.
So now, on the flip side, some argue that this ruling brings much needed stability and clarity. Devin Watkins from the Competitive Enterprise Institute believes that having courts interpret the laws can actually create more consistent and predictable legal standards, which could potentially benefit industries that have struggled with fluctuating regulations. There's also the state level perspective, which we need to consider here. So historically, blue states have often implemented their versions of federal regulations, sometimes going even further than required. On the other hand, red states may welcome the rollback of federal regulations and actually avoid adopting similar state level measures.
It's an interesting point and definitely sort of core to the concern here. I think history kind of has an answer for us on the concern about clarity and stability across the country. The original decision of Chevron versus NRDC that created the Chevron doctrine came on the heels of widespread public and legislative frustration over inconsistent lower court decisions. So exactly to your point, we can expect that this decision is going to widen regulatory gaps between states, potentially creating this awkward patchwork of environmental laws nationwide. This could complicate things for businesses that operate across multiple states and navigating different state regulations. An example here is a recent rule from the Department of Labor they created this rule involving investment income under the Employee Retirement Income Security Act. So this rule considers ESG factors in investment decisions, mostly under the guise of future sustainability and future strength of investments. But now that the Chevron deference is overturned, legal challenges from industry groups and Republican attorneys generals might gain more traction against that rule.
Yeah, and that's a great example. So previously, Chevron deference helped uphold the Department of Labor's rule. However, now courts may actually find it easier to reject the agency's interpretation, uh, in return affecting how investment decisions incorporate ESG factors, which has broader implications for financing in sectors like the oil and gas.
Yeah, and it's clear that the Supreme Court decision will significantly impact various sectors. Agencies are going to need to be much more cautious in their rulemaking. Knowing that their interpretations can be easily challenged in court. On the flip side, and definitely, for the American public, this is going to massively slow down the rulemaking strategy and really hinder progress and the ways in which we can move forward with very urgent issues like climate change.
Yes, and as we mentioned earlier, while some see this as a move towards more consistent and stable legal interpretations, others where it will actually impede necessary regulatory actions. Uh, it's a complex issue with strong arguments on both sides. But Hannah, I think it's important to rewind a bit for our listeners and actually delve deeper into how we got here in the first place.
That is a great idea. So Chevron deference originated from a 1984 Supreme Court case, Chevron USA versus Natural Resources Defense Council. The court decided that judges should be deferring to federal agencies in interpreting ambiguous parts of the statutes. These agencies are more specialized, they have more expertise in their respective fields.
And yeah, essentially the idea there was that if Congress passes a law where something is unclear or there is a gap, it is up to the agency itself to fill in that gap. Um, Again, in practice, this gave federal agencies the freedom to create and implement rules without fear of protracted legal battles. But over the years, this deference became a target for conservatives who viewed this as giving too much power to federal bureaucracies. Now, fast forward to recent years, and we see the Supreme Court, particularly its conservative majority, gradually shifting its strategy of agency power. They emphasize that there are major questions of policy that Congress itself must explicitly detail for agencies to act on them. Yet, the Chevron deference as a legal principle has endured until now.
I think that's a great point. So it's important to remember that there are always going to be follow-up questions relative to fair enforcement of a law. The details of the original case, Chevron versus NRDC, are important here. When the Clean Air Act was passed and was addressing power plants as pollution sources to the air, the language defining a source of emissions was simply stationary combustion source, in quotes. The EPA is who was left to define exactly what a stationary combustion source of emissions was. At first, that decision was simply a component of a power plant, and then they changed that definition to mean, okay, it's not, you don't need to go through the permitting process of putting up a new smokestack as its own stationary combustion source. We will instead consider your entire power plant as a stationary combustion source. The NRDC took issue with this. They did want power plants to individually apply for permits every time they made a new change to their operations. And the court, fully recognizing that this is a conversation outside of their specific expertise, said, we will defer to the EPA's expertise there. And that is how we've continued on. But it is an important mindset to remember, especially when we're talking about things like climate change and like clean air, clean water, that one specific decision, which could be applied in different states, is still impacting air across a state line. The logic to have any of these decisions be federally made is completely aligned with the priority of consistent and stable enforcement, because the consequences of their enforcement do not stay within the bounds of the state that makes the decision.
Also, I read that some advocacy groups and progressives view this decision as a potential setback for areas like clean water, public health, fair lending, and worker safety, which all rely on federal oversight. So, for instance, the Asbestos Disease Awareness Organization expressed concerns that the ruling could actually impact national environmental safeguards and public health protections. Specifically for the exact same reason, right? That you don't want to have state level, controlling some of these laws here. So they have particularly voiced worries about the potential for policy paralysis as well, suggesting that without Chevron deference, federal agencies might actually face challenges in addressing new and emerging issues effectively. So finally, where does this leave us? Federal agencies might become more cautious in their rulemaking, knowing that their interpretations could be more easily challenged in court. This could slow the implementation of new regulations and affect progress on critical issues like climate change.
Exactly. Congressional law almost never spells out the exact details needed to go straight from passing to enforcement. I'm certainly expecting to see laws take longer to pass, spend a longer time being negotiated over, and once they are passed and rules are enforced, we can also expect to see lawsuits continue to jam up the courts. But we will have to wait and see, and we will cover it here. So that's all for today's episode of the Week of Sustainability. We'll continue following and update you on new developments.
Workiva Carbon provides organizations with an easy-to-use solution to manage the full life cycle of measuring, managing, and reporting carbon emissions. Now integrated into the same platform used to manage the world's most trusted financial and non-financial reporting. Don't forget to like and subscribe to this show on our YouTube channel or your favorite podcast platform. See you next week.